All rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. Good morning. We are here in tax case number 22-0005. We don't get a lot of these cases. 5133 North Central et al. Versus Maricopa County et al. As I believe you're all well familiar, we record and live stream these proceedings, so please announce yourself and your client when you stand up. You have a maximum of 20 minutes per side. You are not required to use it all, but if you are intending to save some for rebuttal or split your argument, it's up to you to manage your clock, which you can do on the podium there. We have read the briefings, studied the record. We discussed the case this morning in conference, and with that, please proceed.
Thank you, Your Honor. May it please the Court, my name is Jim Wright. I'm appearing today on behalf of the taxpayers involved in this action, and with me at council table is Paul Moore of our law firm. This case concerns the calculation of limited property values pursuant to ARS 42-13302, commonly known as Rule B. And that statute requires the determination of levels of assessment of full cash value, and it is how that assessment, that level, is determined that is at the heart of this case. As a foundational issue, I think it's very important to understand that an issue the court needs to decide is whether the legislature intended county assessors throughout the state to use the same method and standard to determine this level of assessment, or whether it intended to grant, and whether it legally could grant, county assessors the choice to create their own standards to determine this level of assessment, and whether they could pick and choose among different methods to establish those levels of assessment. Our position is that the legislature has made clear that county assessors must determine limited property values uniformly throughout the state, and that the legislature could not delegate that authority to county assessors, even if it chose to do so, which we don't believe they have done. There are two methods predominantly discussed in the brief to determine this level of assessment. One is known as the aggregate method, which is simply taking the aggregate sum of the limited property values of what we call the Rule A parcels, or the similar parcels that are called for in the Rule B statute, and dividing that sum by the aggregate full cash value of those same parcels. Maricopa County has created its own method to determine this level of assessment. It's an average of percentages method.
Is Maricopa the only county that uses the average?
The record that it's the only county in the record that indicates that it uses that method, Your Honor.
Okay.
I believe in the record there's information from 13 different counties. 12 of those use the aggregate method. The department for decades used only the aggregate method, and Maricopa County uses the average of percentages method.
And
so
we
since this litigation commenced, have any other counties begun to use the average method?
Since this litigation commenced, I honestly don't know. I have not followed up or checked on that, Your Honor.
Thanks.
There are a few key facts that I think are particularly relevant that may be helpful to the court to determine the issues presented. First, all parties agree that the aggregate method complies with the statute. There's no dispute about that. The county agrees with that. The Department of Revenue agrees with that. Second, the aggregate method is the only method the Department of Revenue used for decades when it determined levels of assessment for various counties. Third, the aggregate method is the only method the department teaches in its assessment procedures manual. Fourth, nearly every county, as I mentioned, uses the aggregate method. And finally, and quite significantly, the method used by Maricopa County produces different levels of assessment than the aggregate method. Before I get to the language of the statute, I want to just mention a couple of foundational principles. The first is the one I mentioned just a minute ago, that the legislature intends for all assessors to use the same method to determine limited property values. We know that because the statute 42-13002 provides the following. The department shall exercise general supervision over county assessors in administering the property tax laws to ensure that all property is uniformly valued for property tax purposes.
Counsel, I'm sorry, where are you at in that statute?
That is the statute 42-13002.
Oh, I am looking at the wrong statute. Okay, thank you.
42-13002. It's a very important statute. We cite it multiple times in our briefs. We know that this determination of valuation applies not just to full cash value, but to limited value because of how the legislature defined valuation in the statutes.
Counsel, I just want to clarify something you said. You're saying the language of 42-13302 requires...
002.
002. Okay. So you're saying the language, the statute you just cited requires all county assessors to use the same method.
Yes, it tells the Department of Revenue, supervise these county assessors, and the words are, quote, to ensure that all property is uniformly valued, close quote. And in the legislature's definition of valuation, which is found in 42-11001, subsection 18, the legislature defined the word valuation as follows. It means, quote, the full cash value or limited property value that is determined for real or personal property as applicable.
Mr. Wright, does the, on 13002, do you think that could be read to ensure that all property is uniformly valued for property tax purposes, uniformly within each county? Or you're saying that's uniformly through the state?
Clearly uniformly throughout the state. It refers to all property, not just, it doesn't say property within a county. There is, if you just step back and think about it for a minute, you can obviously see why the legislature, which governs the state, would want things done the same way within the state. And an appellee's position rests almost entirely on the position that county assessors can choose whatever method they want to determine limited property values. And we don't believe that when you read the statutes I mentioned in harmony with 42-13302, that could possibly be the conclusion. Another fundamental principle, again, is that these different methods that Maricopa County uses, or the different method, produces significantly different results, shifting the tax burden by hundreds of millions of, if not billions, of the assessment of limited property values. There's no discernible reason why the legislature would want to give county assessors that kind of authority. The appellee's responses to this difference, this tremendous difference, is interesting. The department's position is that it doesn't matter. It's completely irrelevant, that as long as the county's method complies with the statute, that's the end of the story. As its witness testified, is it your testimony that the aggregate method and Maricopa County's method of establishing Rule B ratios can both be correct, even though they produce Rule B ratios that are not comparable? Answer, correct. Yes, that is their position. They believe, the department's position is that it's appropriate to assess the same class of property differently depending solely on what choice of method an assessor chooses to employ. The county's position is interesting as well. The county has an interesting statement in its brief regarding this different results. It says, and to provide the court, and most importantly, for this court's peace of mind, the assessor is not asking this court for permission to change back and forth among methodologies at its whim or impose different methods for the different classes of property based on which class will benefit or pay the most money as a result. Obviously, the county is suggesting that if that was what it was asking, that its method would be improper. But that is precisely the authority that the county and the department claim the county assessor has. If this court rules in favor of appellees in this case, both methods and perhaps others would be blessed, and the county could apply to each class of property whichever method it desired, whenever it desired. Respectfully, a county assessor either has the authority or it does not, and we believe it does not. Our case law makes clear that county assessors don't have this authority. In the Trico case cited in our brief, our Supreme Court said that the manner, method, and mode of assessing property in Arizona was delegated to the legislature. And in two cases that we cite, the Southern Pacific case and the Bade versus Drachman case, those are cases that the courts held and recognized that same principle. In Southern Pacific, the taxing authority said, we're going to tax railroad property at 89% of its full cash value. We're going to tax everybody else at 20% of their full cash value. And in Bade, the Pima County assessor said, we're going to tax land at 12.5% of its value and improved property at 23% of its value. All the taxing authorities in those two cases said, the legislature has granted us this prerogative. We have the ability to dictate and determine the level of full cash value at which we will assess property. The Supreme Court in Cochise County rejected that notion, as did the court in Bade, and said no, taxing authorities do not have that authority. In particular, the Supreme Court said...
Mr. Wright, was the court in any of those cases relying on 42-13-002? So this argument that you've made about uniformity throughout the state?
42-13-302, and thank you for the question, because it allows me to go to another point.
And what I mean at 13, let me make sure because they're so similar. 13-002.
No, I don't believe that. I don't
Okay.
believe that was the basis of the court's decisions in those cases.
Is there any court that's taken up that argument to say that 13-002A1 prohibits county assessors or county from...
No, but there are certainly other statutes that suggest that that is a foundational and well-established principle. For example, when it comes to determining the full cash value of property, again, the legislature said the Department of Revenue shall establish guidelines to determine the standard appraisal methods and techniques, and assessors are required, they shall follow the guidelines, not by county, but all assessors within the state. But Southern Pacific and Bade are interesting because in that case, they were decided before the concept of limited property value was established, if you will. All taxes at that time were based on the full cash value of property. Now, all taxes are based on the limited property value of property. But the conduct was the same, and the consequences in both of those cases are the same. The police try to distinguish those cases just saying, oh, but that was a long time ago. That was in the 60s, the Wild West, I think one of the police says, of when taxes were being established. But in both cases, the courts quoted this language: what the legislature cannot do is to delegate to an administrative official not only the power to fix a tax rate, and it was referring in that sense to a level of assessment of taxation according to a standard, but also the power to prescribe the standard. And that is precisely what Maricopa County claims it has the authority to do in this case.
So let me ask you this then. Why is the aggregate method the correct method then to use as opposed to the average of percentage method? Is it because traditionally or historically that's what the department's recommended?
Certainly we can make the argument. In fact, this court and others have said when a statute has been interpreted a certain way and is acquiesced in for a long period of time, then it should be upheld. But the language of the statute, Your Honor, I believe also supports that proposition. If I could, I'll turn to that in just a minute. Well, no, I should turn to it right now. You've asked the question. Section 42-13-302 gives direction regarding the calculation of Rule B ratios, and it provides that limited property value, quote, shall be established at a level or percentage of full cash value that is comparable to that of other properties of the same or similar use or classification. The one critical word there is the word that after the words comparable to. And that clearly is referring to a level or percentage of full cash value of what we call the Rule A parcels that are used to establish the Rule B ratio. Thus, the statute means that the Rule B ratio or the Rule B limited value shall be established at a level or percentage of full cash value that is comparable to the level or percentage of full cash value of the Rule A parcels. The statute clearly contemplates an examination of those Rule A parcels on an aggregate basis. It requires that one determine the full cash value of the Rule A parcels. And the only way to do that is to aggregate their full cash values. That is the full cash value. Similarly, It refers to a singular level or percentage. Perhaps this is best illustrated by the county's argument. The county says it attempts to really rewrite the statute, arguing that the statute includes, quote, the statute plainly indicates that the ratio is derived from levels or percentages of the sample. The statute says no such thing. The county's interpretation would alter the meaning of the statute. The statute does not refer to levels or percentages of full cash values of the Rule A parcels, or those of the Rule A parcels, or the average of those of the Rule A parcels. Again, it contemplates an aggregate consideration. And finally, the county's method doesn't comply with the comparability requirement in 4213-302. That requires that the level of assessment must be comparable to the level of assessment of the Rule A parcels. By examining, as they do, and taking each ratio of every Rule A parcel, 1.5 million parcels, they use ratios that range from 1%, literally, to 100%, and everywhere in between. Those ratios clearly are not comparable to the ultimate Rule B ratio or level of assessment that is determined. Could the statute have been written more expressly? Yes, we would all hope so. But we believe that the interpretation of the language in the statute clearly contemplates the consideration of an aggregate method. There are
Counsel,
other points to make.
I'm just having a difficult time understanding your argument. So how is it that the average method doesn't comply with 13302 when both methods yield a single ratio based on data from the full cash value and the limited property values of each Rule A property in a class?
Both methods, if you will, Your Honor, use the same raw data. It's the manner in which the county uses that data that I don't believe is appropriate. We don't believe is appropriate for the reasons that I've just articulated. One, the statute calls for a singular determination, a singular consideration of the level of assessment as opposed to different levels of assessment. The statute certainly doesn't call for the average ratio of the 1.5 million Rule A parcels. So I believe that the language of the statute supports the taxpayer's position. In addition, of course, going back to what Judge Williams asked earlier, we have here the department's continued use for decades of the aggregate method. Clearly, the department believes that the aggregate method, as does the county, complies with the statute. And the issue that we can't run away from, if you will, not suggesting that you would, but it is how do you deal with these disparate results that both methods produce. And we don't believe the legislature can simply say to an assessor, you get to choose. You want to assess land at 62% of its full cash value under your method? Great. You want to assess land at 73% of its full cash value? Great. Mr. Assessor, you get to make that determination, and you get to shift billions of dollars of assessment in limited property value. I'd like to reserve the remainder of my time for rebuttal.
Thank you.
Good morning, and may it please the court. I'm Joshua Carden. I'm here on behalf of Maricopa County, and Mr. Freeze is here on behalf of the Department of Revenue. The only way the taxpayers win this case is if this court reads the statute and decides that it forecloses the Maricopa County Assessor's methodology for assessing Rule B ratios. The parties all seem to agree that the starting place for this argument is the text of the statute. However, the text is not written as prescriptively as the appellants would have this court believe.
By text of the statute, you're referring to 13302, correct?
Yes, Your Honor.
Can we go to 13002 first?
Sure.
And you've heard your colleague explain, he reads that statute to mean the department shall ensure that property is uniformly valued for property tax purposes throughout the state. Do you agree with that reading of that statute?
In part, that's the text of that statute, but the legislature has also seen fit to specifically delegate to the department the authority to write the guidelines for the assessors in making specific determinations. And the tax court.
Okay, so to be a little more specific, you would read 13002 to mean that the department's ensuring is ensuring statewide uniformity, not uniformity within County A, uniformity within County B, correct?
I think it's both, and the reason why I'm saying that is for those statutes where the legislature specifically tells the department to prescribe guidelines for particular activities, and the tax court listed off a few examples in its judgment. So for those, that would mean statewide uniformity, because every assessor has to follow that method to do one thing or another.
So other than this statute, do you have another example of where an assessor, county by county, could vary in how they value property?
In how they value property? Yes. I mean, the basic example would be in valuing property, the legislature says you're going to look at the income method, the cost approach, the sales comparable approach. It does not say every assessor should use one of those three approaches for a particular kind of property. So if you lined up all the assessors in the state and showed them a piece of property, it is theoretically possible that each one of them could choose a different one of the three, as saying, oh, we think this is the method that best arrives at the fair market value of that particular property. The legislature told the department to give guidance on how to do that, but it didn't say, and you must pick the cost approach, except in certain statutes where we do have the legislature saying, and no, we're going to do a specific statutory valuation method here, that this is the only way we're going to value a particular kind of property. Golf courses, for example. There are several examples within the statutes. So the guidelines from the department are not specific in this case to say this is how it must be done. But even if it were, the language of the guidelines at issue instruct the assessors to say, look, we're looking at the relationship. The Rule B factors are developed based on the relationship between the full cash and limited values, that's where that plural language comes from, of existing properties that are subject to Rule A. This is our brief at page 20, quoting from the manual as quoted from the tax court below. So even in the guidelines, the appellants are correct. The examples they give use the aggregate method, but the actual language of the manual seems to say, no, we're actually looking at the relationship, the ratio, the percentage between full cash and limited values of existing properties. And that's why, I mean, when we're looking at the language, I do take issue with one of my colleague's statements when he was quoting from the statute. He said that the thing that we're looking at is a level or percentage of full cash value that is comparable to the Rule A parcels. That's not the language of the statute. And this is where the legislature's permissiveness comes in. It comes in my opinion, in three different places. One is by the gaping hole between the words of other properties, of and other. There's no all there. If it said of all other properties, appellant's argument might have some teeth. It doesn't say all other properties. That implies it can be a subset of the total Rule A property listings for each class. The second layer of permissiveness comes in at the end of the statute. What are we looking at? Comparable to that of other properties of the same or a similar use or classification. Use and classification in this context, there are use codes that properties are given, and then there are very broad statutory classes. The idea that the legislature is being prescriptive in this statute and saying there's one way to do this, they don't even tell the assessors how many properties to use. And this court has, I believe, taken under advisement the Machu Picchu decision. In that case, then tax court Judge Viola found that most of the other counties use a subset of the Rule A parcels. They use market areas and neighborhoods.
And that was the issue in Machu, I think, is whether that was statutorily or constitutionally allowed.
Correct. And I'm only using that as something to point out that, contrary to what appellants perhaps wish to be true, the other counties do not apply a county-wide aggregate method. Let's take that a step further. If the appellants are correct that the point of 13002 is to ensure statewide uniformity, why stop at the county border? Why not say that, that statute means that we have to use all other Class 1 properties throughout the state to arrive at the Rule B ratio? Why say it's limited? If statewide uniformity is the goal, why stop at the Maricopa County border?
Because doesn't the Arizona Constitution put the onus on the counties to levy taxes on a county basis?
Of course it does. But I'm only using that to suggest that if statewide uniformity is the only goal according to 13002, then that would seem to imply that all the assessors have to pool their data and make sure that they're using the same Rule B ratio across the board for every class of property within each of the counties.
And why would we need county assessors? Wouldn't we just have one statewide assessor?
Let's just strike it all down and go back to making the department do all the work. Now, exactly. We've changed the system to say, no, the assessors have the ability to choose several things in this very statute. How many properties they're going to use as a comparison. What type of property is it going to be based? Are you going to group your similarities based on use? Are you going to group it based on classification? And our argument from just a purely grammatical standpoint is the important that. I agree with the appellants that there's one important that there. What are we looking back? What's the antecedent for that particular word? And we say it's the level or percentage. That's what the legislature instructed the county to do. You could argue that Maricopa County, an argument could be made, is the only one that's doing it according to the statutory language. We don't need to establish that here. We're simply saying the language is broad enough to allow for the various methods employed.
So could Maricopa County, the assessor, when there's a change in assessor, I don't know how frequently that happens, but even with the same assessor, can he change his or her mind on which method is appropriate?
I think it could. The difference would be, apart from what the appellants have argued, I don't think it would be appropriate to do that for one class, which is what the taxpayers are hoping for. They're hoping that only Class 1, the commercial property class, gets this, gets the refunds in this case, because, and if you look at the chart we've provided, the same method would require Class 2 to go up 16% in 2018.
But if a county assessor can go back and forth on which method is used, doesn't that defeat the purpose of 13002, which is trying to provide a uniformity and evaluation?
It would seem so. And here, I guess here's the thing with just the practical reality of this is deploying a system that changes every year is like the counties aren't interested in sudden change every year.
You're saying as a practical matter, it's not likely to happen.
Not likely to happen because the system has to be in place. New people come in, have to be able to deploy this system. Old people leave, to say, this year let's use the aggregate method. Or worse, and this is a thing I think could genuinely be prescribed, let's wait and see what the outcome is before we make that determination and just do the one that gives us the most tax revenue. I think that would be potentially problematic. There's no argument that the county has done anything other than apply the same method, the same way for all three of the years at issue in this record, and there's no intention in the record that the county wants to change and do it differently. They like to keep the system. The idea that the legislature got so granular as to say only the aggregate method can be used in this statute is simply not supported at all by this language. All of the other case law that the appellants have pointed to involve an assessor actually doing something that would change the tax rate assessed. They were actually, again, the Beatty case in the I believe it's the Van Gilder case, they were doing things that would have actually set policy for the counties. In this particular case, they've looked at this as a simple math problem and said, what are we going to look at? Do we have to look at all of the Rule A parcels in the county? Oh, not according to this statute. We just have to look at some other. And again, if you want to look at the guidelines, if you think the guidelines are mandatory, the guidelines say just make sure it's a big enough geographic area. Just make sure that there's enough comparables to provide a reliable ratio. That's as permissive a language as, in the guidelines as it, in our opinion, is in the statute.
To your knowledge,
we trust you.
To your knowledge, have any other counties employed the ratio average method?
To my knowledge, no. And again, part of that information, I will be candid, comes from my reading of the trial court's ruling in the Machu Picchu holding, which I did attach as an appendix to our brief, but it looks like from there, Maricopa and Pima are the only two that don't use the neighborhood market area listing. And for whatever reason, it does not appear that Maricopa or Pima have ever bothered to use the use codes as a subset. And that's why I keep coming back to, the missing word in 13302A, Rule B, is the word all. Taxpayers are saying that that statute mandates that the county must use all other parcels in the particular class of property. That word is not in there. It says other properties of the same or similar use of classification. You can't read the statute to say the word all when it clearly doesn't exist. In terms of the difficulty that the appellants have posed is to basically suggest that somehow, this Rule B statute is somehow unconstitutionally vague. There's not a constitutional challenge to this particular statute, but that's essentially what they're arguing, is that somehow the legislature has made an unlawful delegation to the assessors. We say no, the legislature has made a perfectly constitutional delegation, just like the legislature doesn't tell the assessor what color the paper has to be that we issue our notices of valuation on every year. There is some flexibility within the statute, and as the court said in Ada Renta Trust, the dominant principle is let's do uniform rules within the county. The rules are enforced here completely uniformly. They have been, and one class of and the taxpayers have come in and said, Judge, please give us a ruling that benefits one class of taxpayers. Never mind the chaos that's going to create. As if the court says this is the only rule, what do we do about the other classes of property that aren't before the court? It gets very, 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 very crazy very, very quickly, which is why we're asking the court to simply read the statute the way the county reads it and say that their method is permissible. If the court has other questions for me, I'm happy to answer them. If not, I will cede the rest of my time to my et al., Mr. Freeze.
Thank you. May it please the court, Jerry Freeze, appearing on behalf of the Department of Revenue. In addition to the Rule B statute itself, the other 800-pound gorilla in the room is ARS 42-15005. And plaintiff avoided talking about that in their reply brief, and they avoided talking about it today because 15005 sets forth a clear aggregate methodology for determining a ratio. It has to do with setting a ratio for Class 5 properties, an assessed valuation ratio. And it says take the aggregate full cash value of properties in Class 1 commercial properties, divide that into the aggregate limited property value of Class 1 properties, and the resulting percentage is the ratio that should be used. So the legislature is plainly aware of an aggregate methodology to determine a ratio for property tax purposes. They did it in 15005. They didn't do it in 13302. They could have done it. They didn't do it. And their case in chief is basically, we want you to interpret 13302 along the lines of what the legislature did in 15505. They didn't do it. They left it up to the county assessor. And so they didn't do it. One additional thing they didn't do is they didn't tell the Department of Revenue to come up with a ratio. They will tell the department to come up with such things as depreciation schedules and the like. They didn't tell the department in this case. What they said is, as we briefed, they gave the county assessor an objective. Come up with a ratio. Look at comparable properties in Class 1, Class 2 for a Class 1 Rule B ratio. Look at Class 1 ratios and come up with a ratio comparable. And I can't think of any methodology more comparable than just simply adding up ratios, dividing by the number of properties, and having a resulting ratio. As a matter of law, they certainly didn't prohibit that. And that's basically their case in chief, that the legislature prohibited the ratio averaging method and prescribed the aggregate method. And they plainly didn't. And that's why I
Counsel,
think...
two questions.
Sure.
I think I wrote the statute down wrong. What was the statute you were just reading?
42-15-005.
Okay. And then the second question on that I asked your co-counsel on, or colleague on, 13002, that Mr. Wright had talked about the department's role in ensuring that all property is uniformly valued for property tax purposes. Is it the department's position that that statute refers to statewide uniformity or uniformity within each county?
Well, I think it's directed towards statewide, but it has to do, it's a very broad concept. They want to ensure, this goes back to the early 1960s when it was truly the Wild West. And the county assessors were doing a variety of things. One county would value a railroad at X, and the county next door would value it a massively disparately valued based upon a different method. And so they told the Department of Revenue, and that's in fact when the Department of Revenue effectively got created to ensure uniformity. Judge, you're correct. The uniformity clause in the Constitution only deals with uniformity within a particular taxing jurisdiction. So it could be the county, it could be a school district, could be whatever. On 302, the statute, that deals with full cash value, not limited property value. And we briefed that below before the tax court. It was really a throwaway argument on their part, I think, in their brief, because they cited it in a footnote. So it's designed to gin up an issue where none really exists.
So you're saying 13002 is not
a limited
particularly helpful in
Correct.
Analyzing 13302?
It has to do with full cash value. When you value property, ag property, a railroad property in Cochise County versus Maricopa County, it should be uniform. What it doesn't go to is methodology, and that comes up in the Lake Havasu case that we talked about. In the Lake Havasu case, I think it involved a condominium property along the river, and the county assessor valued it using, say, the market approach, and the plaintiff came in and said, well, you should use the income approach. Okay, and the court said, we're not going to get into methodologies. That's up to the assessor, okay? So in terms of uniformity, Cochise County may value a commercial office building under the income approach, and that's their right. The income approach is a valid valuation.
Let me push back just a little bit.
Sure.
Looking at 13302, the limited property value is established based on a full cash value determination, right? A level or percentage of it.
Correct.
Correct. So
Right.
help me again understand how 13002
Well,
has no-
1302 is just, again, a broad concept. Properties shall be valued. You shall ensure that properties are valued uniformly. 13302 has to do with limited property value, and that doesn't go to limited property value. Limited property value is a statutory valuation. A Rule A is a statutory valuation. You bump it up by 5%. And the Rule B is just simply look at data, look at the market data. And this will fluctuate based upon, the ratios will fluctuate, just like values fluctuate, values for office buildings. So if I have $1 million office building and the limited property value is $1 million, it will be a 100% ratio, okay? The next year, the value of the office building will go up to $2 million. But the limited property value will only go up by 50 grand, 5%. So now you have a ratio of like 55%. It's purely a function of full cash value.
I know you're almost out of time, but I'd like to ask another question.
Sure.
So are you aware of, are there other scenarios, and forgive me if I'm not using the correct terminology, this is your world every day and I'm trying to get into it. Are there other scenarios where from county to county, and set aside Machu, because Machu's under advisement, are there other scenarios where property valuation varies, the assessors, how they value it varies from county to county, and it's acceptable?
If Pima County adopted an income methodology for valuing an office building, and the income methodology is a valid methodology, but the Maricopa County assessor adopted the sales comparison approach, so the two methodologies will differ. but they both yield values that are proper and appropriate and determined under appropriate appraisal methods and technology. So the fact that you have different methods doesn't invalidate one method over the other. And in the case of this case, as Judge, you pointed out, why don't all of their arguments about two different methods invalidate the aggregate method? If neither is prescribed, then they're both invalid. Then all these other 12 counties, whether it's 12 or 2, they don't have the authority to adopt the aggregate method.
Okay.
So
Thank you.
Thank you.
Counsel?
Thank you. I'll be brief, necessarily so. Both the county and the state agree that 42-13-002 applies statewide. The argument that Mr. Freeze just made that it only applies to full cash value is belied by the language or by the definition of valuation by the legislature. The statute that answers that question, Your Honor, is 42-11001, subsection 18, which defines valuation as the full cash value or limited property value that is determined for real property or personal property as applicable. That's point number one. So it doesn't apply. This statewide, the legislature's desire that assessors do things the same way doesn't just apply to the determination of full cash value. Second of all, with respect to Mr. Cardin's comments about which parcels are used to determine the Rule B ratio, there's no dispute about that in this case. We have no argument with the county. They chose to use their entire $1.5 million Rule A.
So they could use a subset if they wanted to.
They could, if they follow the guidelines in the Department of Revenue's manual to make sure they have a sufficient amount to give an accurate Rule B ratio. With respect to the example of Pima County determining market value one way and Maricopa another, Your Honor, both of those methods are designed to come up with the same thing, the market value of the property. Perhaps most importantly, again, that I think I don't believe appellees have addressed here is both methods cannot be correct. You cannot have a county assessor picking and choosing among different levels of assessment to assess property. County assessors don't have that authority, number one, and it is clear that they have the authority to calculate levels of assessment, but they must do so uniformly and according to the standards set by the legislature. What they cannot do is to create their own standard, and they cannot pick and choose which among various standards they wish to employ. And in this case, it is the taxing authority's position that an assessor can do precisely that, choose among different standards to determine the level at which property will be assessed. Thank you for your time.
Thank you, counsel, for your arguments. We'll take the matter under advisement and issue our decision in due course. We are adjourned for the day.